In the case of the European Court of Justice, the cases that are presented that I'm speaking about, and I am speaking about the analysis of the soft law. I am not including here, obviously, the several political mechanisms that there are in Europe, namely political mechanisms that can end up in actions or lawsuits submitted to the Court of Justice about implications that are related with the Public Prosecutor's Office and its independence, the independence of prosecutors. I am being limited to the case laws and jurisdiction within the scope of legal proceedings, which are now promoted by political bodies of the European Union. The idea of identifying a matrix that is going more and more or returning to the trend basis of this jurisdiction, the reserve of judge of what can be undertaken by other entities, including the Public Prosecutor's Office. Also a judgment dated March 2021 about the Direct 2002-58 about privacy and electronic communications, in which the European Court of Justice concluded that Article 15, number 1 of that directive, must be interpreted as precluding national legislation that confers jurisdiction on the Public Prosecutor's Office, namely in the Italian, which was very recently changed or amended regarding this aspect of the jurisprudence of the Court of Justice. Another field that sometimes one can have the trend in having a dialogue and learning to the concept of a judiciary is a concept that we should ask. And some authors also consider that being one international instrument can determine the interpretation when the same words are used in the frameworks of the national legal systems. I think it's important here to use a well-known expression used by a judge of the High Court of Justice in America, a judgment dated 1934, Benjamin Cardozo, category of rebels leads to perversions at national. The tyranny of labels is a fertile root of perversions in constitutional theory. The fact that the concept of judiciary authority within the scope of international ruling instruments, namely the European Convention of Human Rights and some instruments of the European Union, focusing certain competencies, it's not an element to, it's not relevant enough. Or minimum relevant for this concept within the scope of certain constitutional legal systems. I would say within the scope of the legal systems in Italy or in Portugal or in France. All of them are different, independent, autonomous in the development in supranational jurisdictions. The second element of the paradox that I had mentioned at the beginning, the Public Prosecutor's Office as protagonist had a core element and a discussion initiated about 500 years ago with the approval of a document for the creation of a corpus juris to reinforce, to strengthen the criminal protection of the European Union's financial interests, which contain as an essential and innovative proposal the creation of a European Public Prosecutor's Office. This process had multiple vicissitudes and different proposals over the years that is not worthwhile now to remember, but I think everyone knows that culminated in the consideration of another EU body based in Luxembourg, the European Public Prosecutor's Office, which began operating in the 1st of June 2021. This European Public Prosecutor's Office is a single entity within two levels. As a body, with an express qualification with two levels, a central level consisting of a European Public Prosecutor, permanent chambers, and European prosecutors, and another one decentralized, composed of delegated European prosecutors located in member states and who are part of the European Union body but exercising functions in the member states before the national courts. Therefore, the first immediate impact is that this new body of the European Union is also a limited functional scope concerning the investigation. On the other hand, and this is also, well, as I said, is a body with a very limited functional scope concerning the investigation, prosecution, and upholding of a range of offenses, covering only 22 countries, because there is the possibility of some countries not participating. This was the choice of Denmark, Ireland, Hungary, Poland, and Sweden that, for the time being, do not participate. What could we understand? The maturation over more than 20 years culminated in the consecration of an interesting institutional model of the Public Prosecutor's Office, which reveals the absence of the unfoundedness of the thesis, which some still advocate, about the necessary association between a unified and indivisible public prosecutors and monocratic solutions. In other words, with single heads of department and opaque internal procedures that do not allow for the identification and scrutiny of the effective decision makers of the Public Prosecutor's Office. In addition to the external independence guarantees expressed there regarding the operation, with transparent mechanism with the people responsible for, by the way, with specific persons subjectively responsible for the specific decisions of the Public Prosecutor's Office regarding the investigation and prosecution. Remedies for these functions, and also a possibility of recalling the procedure and other control mechanisms that mitigate the risks of atomization. The prosecutors are accountable for, and also the bodies and other members headed in Luxembourg. However, there are factors which may give rise to reservations about its European Union body, namely the system adopted regarding the appointment of the European public prosecutors, and also the margin that exists for the national mechanism. It's a heavy structure for a functional scope which is very limited, requiring, in terms of critical perspective, the maintenance of an intense scrutiny about its conformity with the principle of proportionality. It's important not to forget that when entities are set up within the European apparatus, there is the risk of excessive commitment of self-justification of their hypothetical usefulness, which has given rise to abuses that arouse mistrust among taxpayers which really is present in this set of rules. In the case of the European Public Prosecutor's Office, it cannot have a negative experience or existence. We cannot forget that there are some bad examples, such as an entity very close to the Public Prosecutor's Office, the Court of Accounts or the Court of Auditors, very discussed, not only for the reports produced, but also audits that are pending. And in and also recent judgments of the Court of Justice of the European Union delivered on the 30 September 2021, known as Pinchen case. It had serious pathologies, particularly in terms of omissions. And also representation about the credibility of institutions. Now speaking about the endnotes, the closing remarks. The session is already delayed. Just to say, what are the perspectives? What are the perspectives in terms of a European standard of minimum requirements to be prescribed by institutions within the scope of the European Union regarding the Public Prosecutor's Office? I think the margin for this effect, for this purpose, and speaking about the Court of Justice in particular, this is null or almost null. In the case of the European Public Prosecutor's Office, it is a European Union body, of course, subject to all the existing controls, including the intervention of the Court of Justice regarding the public prosecutors' offices of the several EU members, despite its different differences. These bodies are not jurisdictional and consequently cannot be addressed to the Court of Justice to ask for them to explain what they do. So they are not. They do not fall in according to the Treaty of the European Union. And therefore,
já iria me remeter, por exemplo, para vários dos
I would like to mention some of the judgments. They don't benefit. There is an element that has been core for us to know and to consider it competent for doing judicial reforms.
O argumento tem sido formalmente centrado nesta componente.
Centered in this component of competence as bodies of the European Union.
Por outro lado.
On the other hand, I would like to say that expansionism in this regard, we need to mitigate excesses and enthusiasms regarding these expansions. It's not for the circumstances that some states have certain discomfort with the existing situations that these should promote necessarily supranational bodies interventions, putting them away of its functional profile. I would say here that the recent experience of some of the intervention of the Court of Justice using European norms about criminal procedures and production of proof in dealing with the complexities of the plurality of systems that are not confused, cannot be confused or misunderstood, which is significantly wider than the complexity in conceptual terms and problems of legitimacy facing courts that apply federal constitutions I could say, just to close up, I would like to mention a very recent judgment clearly of the competence of the Court of Justice, the European decision in terms of investigation in criminal law, November 21, Gavanozov, which was fixed motivated. There is a right of appeal regarding hearing witnesses, including other entities, and this reveals that in simple cases, sometimes the connection and crossing of several systems raises difficulties. On the other hand, there is a point also, and coming back to a component of connection, an important point that we should consider, as mentioned before, in some confrontation, if we want to be euphemistic, between the Court of Justice and some constitutional courts that go through or consist of the institutional statutory legitimacy and also model of jurisprudence and model of function of the courts. And here we must recognize that the Court of Justice, regardless of certain legitimate enthusiasms with answers, but there are problems also that, for instance, relate to what is common as well to today's debates, to put together the monolithism of the institutions with the diversity of its elements. It's the importance of diversity of elements. So this is fundamental for safeguarding the plurality and the component of evolution or margin of evolution of the institutions, allowing me to close, to recover or to quote a sentence dated of Charles Dickens Hughes, Chief Judge of the Court of the United States, in a time of tumultuous tensions with the state and federal legislative branches. The issue of votes in the court of last resort is an appeal to the reflective spirit of law, to the intelligence of the future day, when a later decision may right the wrong which the losing judge considers has betrayed the court. I would say this is important to all the institutions, to have room for individual autonomy, and also a value of the interest of the institution as a whole. Thank you.